Okay, we are live. So, welcome to another Caseguru Conversation. Where today I'm delighted to be joined by the wonderful Sana Saddique, who is the founder and director of Collective Law Solicitors. Before starting her very own firm, she was also a partner in a regional law firm. She attained partnership by the age of 30 and launched her own law firm at the age of 32. Sana has been named Most Client Focused Divorce Solicitor 2024. Congratulations. Outstanding Woman in Professional Services 2024. Congratulations. And her law firm was also awarded Divorce Law Firm of the Year 2023 and 2024. So quite a lot there. And you're also the finalist for the British Family Law Awards and Boutique Law Firm of the Year 2024. Quite a lot to get through there, Sana, in terms of a very productive couple of years. And you've also been a guest on our Legally Speaking podcast before. So today you and I are going to be talking all about child custody, support, divorce, separation, domestic issues, etc. But welcome back, and good to be chatting with you.
Thank you.
So let's get into the questions. How does the court determine child custody arrangements? Would love to get your thoughts.
Sure. So when dealing with these sorts of matters, parents often take the view that it's a very open-ended approach, and whatever they say will be completely taken into consideration in terms of making the final decision for it from a judge's point of view. But the reality is that's not what the law states. So although the parents' positions and their views in terms of what's been going on in the child's background will be factored in, there's actually a particular aspect of law which the judges and the courts have to follow. So that's set out in the Children Act of 1989, and there's a particular checklist within that statute which is known as the welfare checklist. And that welfare checklist outlines the key considerations that any judge or court has to take into account when making decisions to do with a child, whether that's to do with where the child should live, how often they should see the other parent, any aspects to do with their schooling, their education, their health, anything at all to do with the child has to be factored into that welfare checklist. So it's a very precise area of law. So although the courts and the judges will take other factors into account, it's not really a situation where parents can just turn up to court and say, well, I take the view that father's not been doing this, or father takes the view that mother's, done X, Y, and Z. It's not based on that. It will be factored in, but the law has to be followed, and that's the most important aspect.
Yeah, no, and thank you for being very thorough on that, because it is an important point that you raise. Let's talk about some of the steps that a parent can take if their ex-partner violates a custody agreement. What can you say to that?
So if there's been a court order already issued, so they've already gone through the process of court proceedings and there's been a decision granted by the judge, and then one side isn't following it, again, parents can often be very tempted to take the rush decision of just immediately going back to court to enforce that order. And in some cases, that may be necessary depending on the background circumstances. But in many cases, if it can be considered, parents should still try and actually talk things through. So before involving solicitors or rushing back to court, it's worth just having a very frank discussion with the other side and saying, look, we've gone through this lengthy process of going to court and having a decision by the judge. We've got this court order. It's not working. Let's try and figure out why it's not working. Why do you keep needing to change the dates? Maybe there's something that can be addressed by a bit of give and take. Mediation could also be really helpful just to iron out some of those nitty-gritty details if they're not aligning after the order's been issued. But of course, if all of that fails or there's a much deeper problem overall, you can go back to court. So you wouldn't have to start the whole process again, but there is a process called enforcement of the court order, which means there's already been a decision granted and it's not being followed. So now you're applying for enforcement of that order. So you just want the judge and the courts to consider the breaches that have happened, why they have happened, and what the solution should be moving forward.
Yeah, and again, thank you for highlighting some of the points that I think are important. Of course, court is there, but in my view, that should always probably be the last resort. And if you can do those things that you've mentioned prior to the best that you can, then hopefully, and equally mediation as well. I think that's a great option if you can get that to happen. But as you say, if it does get to that, then of course, that is the next step. Let's talk about grandparents now. What are the rights of grandparents regarding visitation with their grandchildren?
This can be quite a sensitive one, to be honest, because people
Yeah.
don't realize that unfortunately grandparents don't automatically have a right to see their grandchildren, which I know can sound quite harsh, but under the law, that's what the ruling is. They don't automatically have the right to see their grandchildren. In a general situation, you would hope that matters can be fairly calm and neutral, and extended family can be involved in a child's life. But there are always many cases where parents have a estranged relationship with their own parents. And so when they have children, there's an element of friction there as well. And that can often limit grandparents' involvement in the child's life. If a grandparent does want to have access to their grandchild, again, the first option we would always recommend is just try and speak to the parents, so their children. Speak to them and just try and see if there's a way forward that can really resolve the problems which are arising. Now, the reality is sometimes that could be a very long-standing, deep-rooted problem if there's been friction in their own relationship, which is then causing this knock-on impact in terms of not wanting them to be involved in the grandchild's life. But sometimes that element of communication between the grandparent and the parent, it's just what's needed. It helps the parent feel reassured that this isn't going to necessarily be a repeat of their childhood, and their parents, as the grandparent, just really want to have the opportunity to have some input now in their grandchild's life. And sometimes it's a way for them to make amends, even if they feel that they weren't necessarily there as much as they may have wanted to be for their own children. And spending time now with their grandchildren is a way for them to really heal their own wounds, but also really try and be there for that grandchild. So that level of communication should always try to be the first point of call. Again, it's not always going to be an option depending on what the background issues are. But again, things like mediation could always help. And again, as a final resort, a court application. But grandparents have to remember, because they don't have the legal right automatically, they have to get the court's permission before they can make a court application. So there's an option there for them to make a court application for the case to be assessed and a judge to consider, should this person be involved in the child's life? What would the benefits potentially be? What sort of harmful factors need to be considered? But before they can get to that, they need to get the court's permission to make that application.
Yeah, and it's a very important point. But I also like that you talk about maybe it might be a chance to make amends. Particularly, we're all humans. We all make mistakes, and obviously everyone has their own individual circumstances. But what a great way potentially if you could, if you do have maybe a contentious relationship with a parent, maybe sit down and work that through, because the interest of the grandchildren probably should be put first, and having as much love and joy and people around them, the better. Again, I appreciate it's not always that straightforward and there's different circumstances, but I think it's really good of you to sort of highlight that. Okay, let's stick on this before we move into divorce and separation, because obviously child custody and support is a really big and important topic that we want to cover today. What should parents know, particularly about child support obligations and calculations?
Well, the first thing I would say is the fact that there is an obligation. I think many people sometimes take the view that they can avoid making payments, or there's options to sort of argue as to why they shouldn't make the payments. And again, usually these stem from the nature of the background within their own relationship, whatever the reason for the breakdown of the relationship may have been. And that bitterness and hostility sometimes carries through. And one side takes the view that because, for example, one parent had an affair or there was some sort of issue there, they shouldn't feel obligated to now contribute financially moving forward, especially if they're not necessarily going to be involved in the child's life. But again, it's very important to remember here, these payments have absolutely nothing to do with the adults. There's nothing there which is about payment to the former spouse or the former partner, the payments are specifically for the purposes of the children, and making sure that that payment can go towards their needs and their expenses. So it's very difficult sometimes for parents to understand and to accept that regardless of their views, regardless of how involved they may or may not be in a child's life, there is an obligation for them to still make that payment if they're not the parent which is taking care of the child on a full-time basis. And there's no way that this obligation can be overridden. So you can't, for example, just sign an agreement with your partner and say you're not going to make any payments. It doesn't work like that. This is an aspect of law which is prescribed. So there's a legal obligation for that parent who's not taking care of the child on a day-to-day basis to financially contribute for their needs. And again, that's the biggest part. It's for the child's benefit and their costs.
Yeah, no, and again, thank you for highlighting super important points, because you, like you say, we need to be thorough when it comes to this, and we need to make sure that we are adhering to what is absolutely required. I want to move now to, as I mentioned before, divorce and separation. Again, a very sort of, tough topic, but I think it's important that we cover some of the key questions that we're going to go into. And I want to start with, can you explain the new no-fault divorce process and its implications?
Yes, so we now have the no-fault divorce process, which overrides the need to sort of fit within certain parameters to justify why you're wanting the divorce. So previously, there were particular grounds upon which the divorce could be made, which was one side's committed adultery, or there's been a separation for 2 years or 5 years, or there's been a desertion to consider. But now none of that is factored in. It's a no-fault system, which means when you make a divorce application, it's purely on the basis that you feel that the marriage has broken down beyond repair. So it's what they call the irretrievable breakdown of the marriage. And as long as you feel that that's what has happened, the court does not need to know anything else. You don't need to give any reasons. You don't need to give a whole explanation of the background circumstances. You don't have to give any evidence or anything at all. And the reason for that is to try and take the hostility out of the process. It's no longer a blame game. And you're no longer trying to force yourself to fit into one of those predetermined boxes as the system dictated previously. So it's a much more open-ended process now, but it does mean that you have to be really considerate about, is this what you want to do? Because the process is easier overall, but it can also lead to applications being made in haste, unfortunately. So to try and counteract that, the court has made mandatory waiting times and reconciliation times between each stage of the application process. And the reason for that is, again, because the process is now much more straightforward, it just forces the couple to really think about, is this definitely what I want to do? And sometimes, unfortunately, when the process is so straightforward, as soon as something happens in a relationship, the answer is rush to make a divorce application without really considering, was that really necessary? Is that really what I wanted to do? Can things like marriage counseling or therapy or anything else really help them fix the problems or overcome some of the challenges that they are facing? So those mandatory waiting periods between the stages now are designed to really make sure that couples do think about things seriously before following through with the process. But the general process does mean now it's much more straightforward. We no longer have a blame game.
Yeah, and I think that's good, particularly thinking about it from maybe more grown-up children's perspectives that might be very visible to this, and perhaps not he said she said scenarios, but like you said, also this does need to be given some thought, and there are other things you could maybe consider before just going to that no-fault divorce process like you outlined. So thank you again for being very thorough on that. Let's talk about assets now. Again, money, things like that can always get quite complicated. How are assets divided during a divorce, and how can one prove joint ownership?
So when it comes to separating the finances after a divorce, there's so many different ways it can be addressed. And it's really important for people to consider all options, again, before rushing to the court process, because the court process can be very lengthy and very expensive. And unless there's substantial wealth involved or substantial level of disagreement and dispute involved, it may not actually be cost effective to go through that process, because anything you're likely to achieve from a settlement is equally being paid out in legal fees and court fees. So the reality is you want to try and find the most logical balance overall. Now, sometimes that could be, depending on the circumstances, if a couple are on speaking terms still, to talk to one another and actually sit down and say, look, we know what our finances are better than anyone else will. Let's lay everything down, have a look at the bank accounts and talk through what we actually need to be able to move forward separately but independently, and come to their own terms of agreement. They can then come to a solicitor to have legal advice on that agreement, so we can guide them as to whether it's a sensible solution to move forward, or whether there's factors that they need to consider which they haven't considered at that point. Mediation, again, is also super helpful, because even if a couple aren't necessarily on speaking terms, but there's an element to finding a way forward on an amicable basis, the mediator can act as that buffer between them and really facilitate that negotiation and discussion process. And again, solicitors can become involved as well to help in that negotiation process. But if mediators or mutual discussions can work, then that's always going to be the best option moving forward. Solicitors can then just come involved to give advice to confirm whether the agreement is suitable, or whether there's other things that need to be factored in before it's drawn up into a legally binding contract known as the consent order. And of course, the final resort, if nothing can be resolved through any other means, whether that's through mutual discussion, mediation, or solicitors, then that's when a court application can be made. And the biggest part of any aspects of this process, whichever route you're following, is financial disclosure. Before anyone can have any meaningful discussions and negotiations, we have to know what finances are involved from both sides. So it needs to be a very frank discussion about laying all the cards out on the table and then being able to start negotiations. If we don't know what's involved, then it's difficult to really negotiate. And often it does happen where there's couples or relationships where one side may be potentially trying to hide assets, or move finances around, whether it's transferring property onto a friend or family member's name to try and dispose of that asset so it can't be claimed by their spouse. It can become quite tricky and messy, but there's always a record, especially with property. There's always going to be a record with the land registry. So if there's any doubt, or if a person doesn't know whether they jointly own an asset or whether it's purely in their partner's name, we can see that information from the land registry records. So there's always things that can be done to try and find a paper trail before we can get really into the nitty-gritty details of negotiations.
Yeah, and again, I'm just thinking, we must see some really interesting cases with people probably trying to be quite creative with hiding assets and this, that, and the other. But I think giving really good kind of practical, tactical insights there is only going to help people. Let's talk about unmarried couples now. Again, this is a bit of an unknown or grey area for people that might be in a a long-term relationship but unmarried. So, what are the rights of unmarried couples concerning property and children?
Yeah, so this is always quite a hot topic, to be honest, because I think in the media especially, we have these little bouts and bubbles where it's talked about intensely, and then it dwindles off, disappears off the radar, people forget, and we go back to square one. So there is no such thing as common law marriage. So if you're living together, you simply do not have the rights of a married couple. There is no law at the moment in the UK which gives you any automatic protection if you're living together as a cohabiting couple outside of marriage. So if there was a dispute, or if the relationship broke down, whether you've been together for 2 years or 22 years, your position is the same. You are not legally protected. And this is something which really baffles people, because they just assume that after being in a committed relationship for so long, there should be or would be something to protect them. But that's not what the law currently states. And it's really important that before any major life decisions are made, you seek legal advice, because there are other things that we can do to assist, such as having a cohabitation agreement put into place before you start living with somebody in a relationship. So it's very clear what the terms and expectations of that living arrangement are, especially to do with future issues such as if you were to break up or to separate. The arrangements of living together are on the basis of XYZ. So you know if things don't work out, you know what you're going to be entitled to by way of a mutual agreement which has been made in advance. And similarly, you can have a separation agreement if things fall apart, but by that stage you're sort of depending on one another actually agreeing and cooperating to terms, which can be trickier because depending on the reasoning for the relationship breaking down, one side may not necessarily be inclined to enter into those discussions, especially if they have the leverage that the property may be registered in their name, for example. So they're potentially protected and covered, and it's the other side that's losing out. So it's really important to get that legal advice as early on as possible. So things can be done to protect your rights and your position. But as it stands under law, there is no automatic protection, unfortunately.
Yeah, and thank you for highlighting that. And as I say to lots of people all the time, take emotions out of it. It's what's in the docs at the end of the
Yeah.
day. And like you said, with that cohabitation agreement, particularly if it's in an early stage and you're just getting together and you're in, buying up, you're getting a flat, whatever it is, what a great time to actually start thinking about that when there's actually no animosity whatsoever. It's just a simple matter of fact document that can be so, so valuable for you as time goes on. Okay, you've touched on it throughout the conversation, but I want to dive in deeper because I think it's a great thing to consider, and that's mediation. So what role does mediation play in resolving family disputes, and when is it appropriate in your opinion?
It plays a huge role in family law, to be honest. And again, this isn't something which we push clients to engage in purely for the sake of adding an extra layer of work for them to do. It genuinely can be super, super helpful for them because when things go wrong, whatever it's to do with, whether it's to do with a marital breakdown, a relationship breakdown, disputes about access to children, so much tension and emotion is involved. And it's really a process of thinking, can we address this in a sensible, amicable way, which will still give us a platform then to have a healthy relationship or co-parenting relationship moving forward, regardless of what's going on personally between the two adults? Or is this a situation which is extremely contentious, potentially an element of domestic abuse involved, or some particular reason why there shouldn't be any direct communication between the parties or through mediation? In cases such as that, court intervention would be completely necessary. But if it's safe to do so, trying to have that amicable discussion could really save people time and money moving forward, as well as just avoiding the need of adding so much extra emotion into the mix. If you're able to resolve a dispute within a matter of a couple of weeks or a couple of months out of court, saving time, saving money, but also maintaining a mutual level of respect for one another, you may have a better chance of really still nurturing that working relationship moving forward. Whereas if you rush straight to court and it becomes a very contentious issue, everyone's throwing blame around, emotions are just being heightened. Maybe the issue doesn't warrant that level of involvement, but out of bitterness, out of hostility, out of emotional reaction, the extreme approach is taken. It can really cause more damage sometimes than benefit because you now potentially lose that ability to have that mutual respectful dialogue with the other person moving forward. So it does depend on the case, and it has to be factored in terms of what the background is. If it's not safe, if there's domestic abuse concerns, if there's anything of that nature, then of course mediation may not be suitable or practical. But if it is safe to do so, it can really be beneficial.
Yeah, and I always say when emotions go up, sometimes intelligence can go down. And, I think, like you say, think about what is the goal? Is the goal to get to here? Well, maybe this, what I would call a system, really. Mediation is probably the best system to use with not as much friction that's going to get you to that end goal. So, yeah, I always encourage people, particularly when it's in any form of, situation, what is the goal? And are you keen to get there as quick as possible? Then think about other systems. It might be a bit more helpful if there's a little bit of give and take along the way to get there. Okay, let's talk about domestic issues now. Again, another very important topic. How does domestic violence impact custody arrangements and divorce proceedings?
Okay, so domestic abuse doesn't really impact divorce as much, to be honest, purely because we have the no fault system now. So the court doesn't take into account any of the background circumstances. You don't have to attend court for any hearings in a divorce process. So there's no risk of having to sort of be face to face with your alleged abuser and having to see them or face them in that respect. It's all paper based, done electronically. So there's limited risk involved there. But if it's in relation to a child arrangements matter to deal with, where should a child live, how much access should they have to the other parent, and so on, then domestic abuse, if it's raised as an issue, always has to be considered in detail by the court. So if one side raises allegations of domestic abuse, the court has a duty. It's now covered under what we call Practice Direction 12J. So there's a very particular aspect of law which dictates if one side alleges an influence of domestic abuse, which either could be directed at them or potentially towards the child, the court has a duty to investigate and assess those risks before moving forward to determine what the arrangements for the child should be. And the reason for that is before they can decide what's safe for the child, they need to figure out what's the level of risk involved. And the only way to do that is by looking further into the allegations of domestic abuse and really assessing, is this true? What's the likelihood of a child being impacted by these concerns? Or is there anything that can be done to ensure the child has a meaningful but healthy relationship with both parents, whilst also making sure that there's protective measures in place to limit any direct contact between the parents if they're the ones alleging the domestic abuse, or if it's for the child, making sure that potentially any access to the other parent is limited or supervised in some way to make sure that they have that sense of identity of knowing who their parents are, but they're not being placed in a position of risk or harm by having contact with that parent. So having a third party or some element of supervision or oversight to monitor how contact is progressing could achieve that balance, but it will always be factored in if it's concerning a child.
Yeah, absolutely. And again, thank you for being very practical about that and giving some helpful suggestions that could hopefully only help people if they do find themselves in this situation. What legal protections are available for individuals who are currently facing domestic abuse?
So the first point of call we would always say is to contact the police. Now, sometimes this doesn't happen because a person could be afraid. They're more focused on trying to escape the situation rather than making that phone call. So the focus isn't so much on making sure you phone the police there and then in the incident, otherwise it doesn't count. You may need to protect yourself first by removing yourself from the situation, hypothetically walking out of the house, going to a family or a friend's, so that you're safe and you're in a safer situation before you make that phone call. But definitely notifying the police is always the first priority. After that, it's a question of what's the nature of the abuse and how serious is the risk involved. There are protections under law, which mean a person could apply for what we call a non-molestation order, which is a court application designed to protect victims of domestic abuse. The threshold for this is set quite high, and it's deliberately set quite high to prevent copious amounts of applications being made. The majority of matters should be able to be dealt with through the police in terms of harassment or nuisance or inappropriate behaviour. But if the allegations are much more severe in the sense that your life has been threatened or your safety is at risk immediately, then you can make this court application, and it's dealt with on quite an urgent basis. So you don't have to go through the usual waiting times for court applications to be processed. They're dealt with very swiftly within a matter of days or a week at the most. And usually these are designed as protective measures to ensure that the perpetrator is no longer able to contact or approach you until the next hearing is listed, and the judge then will hear from them as well, so that they also have their right to give their version of events before any longer term or final decisions are made. But the non-molestation order can act as the immediate temporary protection to protect an individual in that circumstance.
Yeah. Okay. Well, thank you. And yeah, I didn't actually know that, so that's really helpful to know. Genuinely, so I can at least let other people in my community, if they ever need it, about that. And that's why I wanted to get you on the conversation today, Sana. I think you've shared so much wisdom throughout. It's been an absolute sort of joy learning more about very important, serious topics. So I guess I have one final question before we wrap up today, which is, what are some of the common mistakes people make during divorce proceedings, and how can these be avoided?
From my experience, one of the biggest mistakes, which again, it's difficult because as professionals, we know the process. If you're starting the process yourself in person, people often assume that once you've submitted a divorce application, that's it, you're done. You've submitted the divorce application, therefore you're now divorced. It doesn't work like that. There's a whole process and multiple stages of applications that have to be submitted before the divorce is actually complete. But we often get clients coming to us saying they submitted a divorce application online, say 18 months ago, and they're now looking to remarry, but they can't remarry because they're being asked for the certificate of their marital status, and they're very confused. So they've come to get legal advice. And when we're talking to them, we realize that they're under the assumption they're divorced when really they're not, unfortunately. So that's one of the biggest things to remember. Although you can go through proceedings yourself in person, if need be, always try and have at least a consultation with a solicitor, so you know the general process and procedures involved. And if then you choose to go through the process yourself, at least you know fully what needs to be done, so you're completing the full process.
Yeah, devil is in the detail, as they always
Yeah.
say. Yeah, I can imagine that's quite a frustrating and awkward situation some people might find themselves in, if that happens. Sana, this has been brilliant. Thank you ever so much for your time today. If people would like to know more from you, or indeed some of the topics have resonated with them today, or indeed they need your help, how can they get in touch with you? Feel free to shout out any websites, any social media handles. Obviously, we're recording here on LinkedIn, but feel free to share any more contact information.
Yes, sure. So I use my LinkedIn page predominantly, which is Sana Saddique, and the profile for our law firm, Collective Law Solicitors, will be very visible on that, so you'll know it's me. Alternatively, you can reach us by sending us a direct email to the law firm, and my email would be sana, SANA, @collectivelaw.co.uk.
Well, there we have it. It just leads me to say thank you so much once again, Sana. It's been an absolute pleasure hosting you. And please do make sure you give Sana a follow here on LinkedIn as well. But we're going to be doing a whole host of more conversations with Caseguru. We're on a mission to really help people make finding lawyers far more simpler, and indeed reduce that access to justice gap. So please make sure you also give Caseguru a follow. And yeah, look out for some more conversations coming your way in the new year. But from now, thank you so much once again, Sana. And bye bye, everyone. Take care.